The following video is informational and does not substitute legal advice from a licensed attorney. The K-1 visa process. Step 1. The USCIS Filing. The United States citizen sponsor files the K-1 visa petition with the USCIS by mailing the completed I-129F petition package along with a check to the Department of Homeland Security for $340. Step 2. Notice of Action 1 or NOA 1. 2 to 3 weeks after mailing your petition, you will receive a Notice of Action or NOA 1 in the mail, indicating that the USCIS has received your petition. Step 3. Notice of Action 2 or NOA 2. Between 4 and 6 months after mailing your petition, you will receive a Notice of Action or NOA 2 in the mail, indicating that the USCIS has approved, denied, or requests additional evidence for your petition. Step 4. The NVC Phase. The service center that handled your petition forwards your case to the State Department's NVC, or National Visa Center. This will happen within 2 weeks of your approval. The NVC will run a security check on your fiancé. Step 5. NVC to Embassy. Within 4 weeks, if your fiancé's security check comes back clean, your approved K-1 visa petition will be routed to the Bureau of Consular Affairs. The Bureau of Consular Affairs will send your file to the U.S. Embassy in your fiancé's country via DHL. Step 6. Embassy Letter. About a week after receiving your visa petition, the U.S. Embassy, usually in the country of origin, sends the fiancé a letter with instructions for scheduling the medical exam and interview. You, the U.S. citizen, do not have to attend the embassy interview. Step 7. Gather embassy documents. The U.S. Embassy will instruct the fiancé to return some of the documents immediately. Other documents will be kept until the interview. The medical exam. The fiancé must have a medical exam. The package sent to the fiancé by the U.S. Embassy will explain how to schedule the medical exam. You must pay a fee for the medical exam. The fee is usually paid in the local currency and varies from $65 to $200, depending on the location. This fee can't be paid from the United States. Step 9. The Embassy Interview. The fiancé must attend an interview at the U.S. Embassy. All applicants must bring their passport, including children of all ages. If children are joining on a K-2 visa, they must also attend the interview. The U.S. citizen sponsor is not required to attend the interview. However, the sponsor is allowed and encouraged to attend in some countries, while other countries will not allow the U.S. citizen to attend. The embassy fee is paid directly to the embassy. A consular officer will ask a series of questions to determine the relationship is genuine. Step 10. The visa is issued. The alien fiancé may be able to pick up the actual visa the same day. However, there will usually be a wait of up to 1 week. The visa will be delivered via courier. The actual K-1 fiancé visa is a self-adhesive decal that is placed on the beneficiary's passport. At this point, airline tickets can be purchased for travel to the United States. Step 11. Travel to the U.S. The fiancé has 6 months to use the visa to enter the United States. He or she will be given a package of documents by the U.S. Embassy. The sponsor does not need to travel with the beneficiary when they travel to the United States. Step 12. The wedding. The petitioner must marry the alien fiancé within 90 days of entry into the United States. If a wedding doesn't take place within this time, the fiancé must leave the United States. The K-1 visa beneficiary can only marry the person who submitted the petition. Eventually, the alien must file an adjustment of status petition to receive the green card. There is no deadline for filing the AOS, and it does not need to be filed within 90 days of arrival. However, the alien will not be able to work or re-enter the United States before it is filed. Additional items related to the K-1 process. K-2 visa. The fiancé's children who are under 21 and unmarried may be eligible for a K-2 non-immigrant visa. All that is necessary to include them in the K-1 visa petition process is to include their names on the I-129F. Working. After your fiancé arrives in the United States, he or she may apply for permission to work by filing Form I-765, Application for Employment Authorization. The current average processing time for the I-765 is 3 months. AIDS and HIV. HIV is no longer a ground for inadmissibility. This rule was changed on January 4, 2010. Applicants are no longer required to file Form I-690 if HIV infected. Disqualifying events. The following circumstances will disqualify you for a K-1 visa. You committed serious criminal acts, including crimes involving moral turpitude, drug trafficking, and prostitution. You are addicted to drugs. You have a communicable disease other than HIV. You have a dangerous physical or mental disorder. You are likely to become a ward of the state. You have used fraud to enter the U.S. International Marriage Broker Regulation Act, IMBRA. When applying for a K-1 fiancé visa, you must notify the USCIS if you met your fiancé through an international marriage broker. An international marriage broker is a corporation, partnership, business, individual, or other legal entity that charges fees to provide dating, marriage, matchmaking, or social referrals between U.S. citizens and foreign nationals. The following are not considered international marriage brokers. 1. Matchmaking organizations of a cultural or religious nature that operate on a non-profit basis and comply with the laws of the country they are in. 2. Dating services, including online dating services, if their primary business is not to provide dating services between U.S. citizens and foreign nationals. They must also charge the same rates to men and women, offer the same services to men and women, and do not base fees or services on the individual's country of citizenship. For example, they can't charge U.S. men to be a member, but allow foreign women to join for free. Multiple K-1 visa filings. If you have filed 2 or more K-1 visa petitions in the past, you must apply for a waiver. You will also need a waiver if you have had one K-1 approved within the past 2 years. To request a waiver, you simply write a letter stating all available facts about your previous filings. You will state that you are requesting a waiver and attach the letter to your new fiancé visa petition. Using a different type of visa to come to the U.S. for marriage, not a K-1 visa. Coming to the U.S. on a different visa, not a K-1 visa, or no visa, ESTA, with the intent of getting married, would usually be considered immigration fraud. This situation should be avoided. For example, you should not attempt to bring your fiancé to the U.S. on a tourist visa with the intent to get married. The penalties for immigration fraud are steep and can even result in up to 5 years in prison. K-1 visa if fiancé is in the United States illegally. If your fiancé is in the United States illegally, you will not be able to get a K-1 visa. If this is your situation, you should talk to an immigration attorney before you leave the United States.